Meeting of the Texas Commission on Environmental Quality to order. Today is October 23rd, 2019. The time is 9:30 a.m. With us today are Commissioner Emily Lindley and Commissioner Bobby Janeka, as well as our General Counsel, Mary Smith. I'm John Neerman, and I'll ask Ms. Smith to call the first item.
The first item is consideration of the ALJ's proposal for decision and proposed order concerning the enforcement action against SkyPack Corporation doing business as Country Food Store. The order of presentation should begin with the Executive Director, followed by the respondent, and then OPIC. By letter dated September 20th, 2019, the Chief Clerk provided each of the parties with 5 minutes of oral argument time in accordance with the Commission's standard practice. The ED may save some of that time for rebuttal as the ED bears the burden of proof.
And before you get started, Mr. Althoff, are you here?
I'm here.
Okay. Are you comfortable proceeding without a translator?
Yeah, that's fine. They told me it's a little bit too late, so I'm fine with it.
Okay. Well, I'm understanding you perfectly clearly, so I think we'll probably be in good shape. Thank you, sir. Go ahead.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Ian Gretsch, representing the Litigation Division. With me today is Audrey Leiter, also of the Litigation Division, and Stephanie McCurley of the Enforcement Division. This case involves violations of PST rules by SkyPack Corp. At a facility it owns and operates in Buna, Texas. The ED cited respondent for failing to update its registration, failing to inspect its cathodic protection system, and failing to conduct an annual line leak detector test. An evidentiary hearing was held on March 6th and 7th, 2019. During the hearing, respondent testified that the TCEQ had concurrently pursued two separate enforcement cases for two separate facilities it owned. Respondent also testified that it had simultaneously sent compliance documentation for both of its enforcement cases to TCEQ. After the hearing, staff re-reviewed respondent's other enforcement case file and discovered compliance documentation for one of the violations of this current case. The ED then requested that the court reopen the record to admit this evidence and dismiss the cathodic protection violation. The proposed order before you reflects this and cites respondent for the two remaining violations. Therefore, the ED concurs with the administrative law judge's proposal for decision and recommends adoption of the proposed order with the inclusion of the ED's exceptions, which are intended only to clarify the order and correct minor typographical errors. We are here to answer any questions you may have and would like to reserve the remainder of my time for rebuttal if necessary.
And I have none. Colleagues, any questions? Okay. Mr. Althoff, this is your opportunity to address us. If you want to stand at the podium, please.
First of all,
and if you could just state your name and your affiliation for the
yes,
record. Yes.
My name is Umar Altaf. I'm president of SkyPack Corp. First of all, I'm thankful to the commissioners to give me this opportunity to speak about this. This is a very complicated matter, and it is clear from the evidence that both of these cases that Mr. Ein just referred to were investigated together. And on the permission from TCQ, we hired an environmental company to investigate both cases. And TCQ, Ms. Catherine Laughlin, she started accepting the documents from that company. And apparently, she admitted in the hearing, that there was some issue with her laptop. They missed some of the documents. Because of that, we had to go through, hardship, and they found several documents in both cases later. One of the case was completely dismissed, and of course, we were in a situation where my business recently burned down to ground, and we were going through financial hardship. I wasn't able to afford a full-time attorney. I got a help of a part-time attorney, which tried to communicate with Mr. Ein to let him know that there is a possibility that some documents have been lost. Mr. Ein refused to cooperate with us in that matter, and he decided to try this case. in the trial, we found out that there's so many other discrepancies in this case. One of that was that cathodic protection log, which was already dismissed, which was already submitted, was found in a different file. So this case has a lot of doubts, and on the technicalities, and so many documents have been found, and I think this is not, the rule is the benefit of the doubt goes. I mean, we should get the benefit of the doubt, and the whole case should be dismissed because we went through a lot of hardship, and there is a proof exists in both cases that documents have been found later on. And on the other hand, we are the high performer of TCQ. Our record shows that in the previous, I mean, that is true that this time there were some violation, but we corrected all of them in timely manner. As far as the PST registration form, my father's he sent both forms to TCQ, and because he was retiring, he was a heart patient, so he handed over the business to me. But the documents include his statement that he sent a PST registration form to TCQ. So Ms. Audrey, gave us a benefit of doubt, and one has been completely dismissed. On the other one has not been dismissed yet. On the same form, because we were not selling enough super. So super tank was out of service. We also, my father put that on the PST registration form that it had to be out of service. That's why super tank was not tested. And during the hearing, Mr. Ein asked me if somebody go inspect the tank right then. If somebody can do it, even though the station has been burnt now, but tanks are outside, there is no super. It has been already taken out of service. And my father has mentioned that on that PST and ownership change form. So I would request, because I am a diabetic patient, and today, I traveled with my uncle all the way from Beaumont just to, so I get a chance to talk, in front of the commissioners to talk about this. I think there's enough benefit of doubt exists, and they found so many documents, and one of the PST registration form allegation has been dismissed in a similar case, which started, investigation in both cases has started together. They started the investigation together in both cases. So on that basis, I request, that we should get looking at my father's statement, looking at our prior history, we were high performer, looking at everything else. I think the whole case should be dismissed, and we should be given a benefit of doubt. And the way we went through hardship last 2.5 years, because they lost so many documents were found later, I think, this is not fair to us that we are being treated like this, or we have been treated like this. And these allegations should have been already dismissed, but I can only request the commissioners to do that, and ultimate decision is yours. And again, I'm very, very thankful for this opportunity.
Thank you, Mr. Althoff. I appreciate that. Colleagues, any questions or comments at this point?
No questions. Thank you.
At this time.
OPIC.
Thanks.
Good morning, Chairman, Commissioners, General Counsel, and the Executive Directors, attorneys, and staff. My name is Dominique McLagan Brown with the Office of Public Interest Counsel. OPIC agrees with the Administrative Law Judge Bailey's conclusion that the ED met its burden to show that respondent committed the 2 remaining violations as alleged in the ED's first amended report and petition. OPIC agrees that the penalty recommended by the ED is reasonable and calculated in accordance with applicable statutes, agency rules, and TCEQ penalty policy, and past agency practice. Further, OPIC finds that the corrective actions recommended by the ED are necessary and appropriate. Therefore, OPIC recommends that the Commission adopt the ALJ's proposal for decision and agrees that the ALJ's decision to sustain the ED's exceptions as recommended by the ALJ's July 11th letter. Thank you, and we are available for questions.
Thank you. Any questions, colleagues?
No, thank you.
ED, rebuttal.
Unless you have any questions, I'm going to reserve my time.
I think there are none, and appreciate that. Mr. Althoff, let me share my thoughts with you about this matter, and then my colleagues can weigh in with their thoughts. So this is a case that was referred to the State Office of Administrative Hearings, and that's the forum to consider the evidence and the arguments. And I'm sorry for the loss that you've suffered through the fire. We're in a position now that the State Office of Administrative Hearings and the Administrative Law Judge has given us their recommendation. We are somewhat bound by that. That is the forum where they hear the evidence and make determinations about the weight of the evidence. And it's the executive director that bared the burden of proof, and the executive director did that to the satisfaction of the administrative law judge. So what the commission can do is correct the judge if the judge has misinterpreted or misapplied the law, or if the judge has created a clear error in the facts. We can't go back in and second guess and judge the evidence as the commission. That is really the role of SOA. So I don't find any misapplication or misinterpretation of the law. I don't see any error in the factual conclusions on this matter, and so I feel bound by the recommendation made to us by the judge to go ahead and adopt the proposal for decision. I'll invite my colleagues to share their thoughts.
I don't have any additional thoughts. You stated everything very well, and I would be in agreement and willing to make a motion or second a motion that we would adopt the ALJ's proposal for decision.
Yeah, and I guess the only thing I should add, I'm in agreement with both my colleagues. It occurs to me that there were some obligations beyond the loss of documents. There were some obligations that were not met in accordance fulfilling the terms of the license, the permit under which your business was bound to operate in our agency. Maintaining records and proof of the supertanker being shut down is an example where I think I'm very sensitive to your plea, but I'm in agreement with the chairman, and I think it's appropriate to offer a motion right now if you're open to it.
I'll entertain a motion.
I would move that we adopt the administrative law judge's proposed order as modified by the executive director's exceptions to the administrative law judge's proposed order, and recommend by the ALJ in her reply letter dated July 11, 2019, with the following additional modification: revise finding of fact 20 by removing the word "and" located in the second sentence between McLaughlin and "that."
Second.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Thank you for being here today, sir, and I appreciate we haven't given you the relief that you've asked for. I'm sorry for that, but I feel like we have followed our process and appreciate you participating in that process. Ms. Smith, I'll ask you to call the next item.
Item number 2 is the application by Fort Bend County Municipal Utility District number 143 for a major amendment to Texas Pollutant Discharge Elimination System Permit number WQ00152411001 to authorize an increase in the discharge of treated domestic wastewater. The parties have been notified that the commissioners will not take oral argument but may ask question. Several people are signed in on this matter, and the presence of those who have signed in will be noted for the record.
So, colleagues, I understand in this matter that Fort Bend, the Fort Bend Mud and the Blairs have an agreement pertaining to this permit, but TCEQ is not a party to that agreement, and it's also outside our jurisdiction. So I think we just will follow our standard analysis. Clark and Sarah Blair live within a quarter mile of the facility and the discharge point, and they've identified personal justiciable issues, in my estimation, and so I think we should grant their hearing request.
I agree.
Seeing nods of approval. Mm-hmm. And I appreciate that Ms. Blair did not submit comments on her own, but Clark Blair's comments, I think, very clearly were meant to represent her as well. And I would point to his use of the word "we" in expressing concerns about the proposed amendment, so I would grant the request as to both Clark and Sarah Blair. And I I see three issues here, or what I'll summarize as three issues for referral. The first is whether the draft permit is protective of the health of the requesters and their family, as well as fish, wildlife, and livestock. Whether the proposed discharge will be protective of both surface water and groundwater, and whether the facility and the draft permit comply with the siting requirements.
I'm in agreement, and
Likewise.
I can make a motion.
I'm ready for a motion.
I move that we grant the hearing request of Clark and Sarah Blair, that we refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with SOA's preliminary hearing scheduling efforts, that we refer the application to SOA for a contested case hearing on the following issues. A, whether the draft permit is protective of the health of the requesters and their family, wildlife, aquatic life, and livestock in the area. B, whether the proposed discharge permit under the draft permit will be protective of surface water and groundwater quality in accordance with applicable regulations, including surface water quality standards in 30 TAC Chapter 307. And C, whether the facility and draft permit comply with the plant siting requirements in 30 Texas Administrative Code Sections 309.12 and 309.13, and that we set the hearing duration of 180 days from the day of the preliminary hearing until the proposal for decision is issued.
I second that motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Thank you.
Item number 3 is consideration of the petition for inquiry filed by 8 groundwater conservation districts in Groundwater Management Area 16 regarding Starr County Groundwater Conservation District. The Office of General Counsel recommends that the order of presentation begin with the 8 petitioning groundwater districts, followed by Starr County Groundwater Conservation District, then the Executive Director, and finally OPIC. By letter dated October 4th, 2019, the Chief Clerk provided petitioners collectively, the respondent, the ED, and OPIC each with 5 minutes of oral argument time in accordance with the Commission's standard practice, and the petitioners may reserve time for rebuttal as they bear the burden of proof. There are others who have signed in but indicated that they don't wish to speak, and their presence will be noted for the record.
And Mr. Bledsoe, I understand you're here. Good morning, sir. You're first up.
Thank you.
And just confirm that the light is on your microphone, and then you can state your name and affiliation for the record.
I'm Scott Bledsoe, Chairman of GMA 16 and President of Live Oak Underground Water Conservation District. I'm here this morning to support our petition for inquiry to review Starr County GCD. My understanding is that Starr County filed a motion late yesterday afternoon supporting and agreeing with our petition. Therefore, I won't take a lot of time. I'll just ask that you grant the petition for review.
Yes, sir.
Thank you.
Thank you. And Mr. Gershon, are you here?
Yes.
Good morning, sir.
Good morning. Commissioner Newman, Commissioners. Mike Gershon with Lloyd Gosselink, Rochelle, and Townsend. I'd like to introduce you to the Starr County Groundwater Conservation District's board members. We have 3 board members here today. Tom Koeneke here on the second row. We have Rose Benavides and Reina Guerra as well. They've traveled here from the Valley for the item. It's a matter of importance to them. As indicated by the petitioners, there was a motion filed yesterday. The petition was itself was filed late August. I was hired, our firm was retained within the last couple of weeks to assist the district. Our firm is uniquely situated in that we represent about 24 districts around the state with a range of funding. The issue is reflected in the petition is this district, which was formed by the legislature in 2005, has had some funding challenges, and has been relatively inactive. There is a decision to make with these board members and their other colleagues on the board this summer as to whether to look to winding down this district, which would have been one of the options, or whether to bring it out of an inactive state and really to get to work and do the things that a groundwater district is mandated to do under Chapter 36 of the Water Code. We're here today in the interest of efficiency, asking for the Commission's support and peculiarly asking you to grant the petition and form the review panel. What that means is that the statute provides for a 120-day review process. A number of the review panel members are here, we understand, and we believe that's a good opportunity as we leave today to huddle up and get to work and begin that process. As reflected in the motion, the district supports participating in that review panel process. We look not to backward in time, what's been clearly recognized as an inactive status, but rather to the future, and coming back before you after the review process and hopefully having some good news that we've got a plan in place to bring this district into an active status. Thank you.
Thank you, Mr. Gershon. Appreciate it. And thanks to the board members for being here this morning. Executive Director.
Good morning, Chairman Neerman, Commissioner Lindley, Commissioner Janeka, Office of General Counsel, and Office of Public Interest Counsel. My name is Shea Pearson, and I'm here on behalf of the Executive Director with the Environmental Law Division. With me today are Kelly Mills and Abi Barehi with the Water Availability Division. The Executive Director recommends that the petition for inquiry be granted and a review panel be appointed. The petition was filed by 8 districts in the Groundwater Management Area 16 regarding Starr County Groundwater Conservation District's failure to participate in joint planning pursuant to Water Code 36.108 and failure to adopt desired future conditions and update its management plan in pursuance with Water Code 36.3011. The Executive Director recommends granting the petition because the issues raised in the petition are within the scope of Water Code 36.3011B and are supported by the evidence submitted within the petition. Additionally, as stated previously by Mr. Gershon and the President of the GMA 16 Groundwater Management Area, a agreed motion to grant the petition and select a review panel was filed by Starr County Groundwater Conservation District on October 22, 2019, and was agreed to by the petitioners and Starr County and was not opposed by Office of Public Interest Counsel or the Executive Director. For these reasons, the Executive Director recommends granting the petition and appointing a review panel. The Executive Director has collected nominees for panel members and included the recommended names within his brief. We're available for any questions you might have.
Thank you. I have none. Colleagues?
No questions.
No questions for me.
OPIC.
Good morning, Chairman, Commissioners, General Counsel, and the Executive Directors, attorneys, and staff. I'm Sheldon Wayne with the Office of Public Interest Counsel. And after review, OPIC finds that petitioners have presented sufficient evidence to demonstrate that a commission inquiry is necessary regarding Starr County Groundwater Conservation District's operations. As explained in further detail in our brief on file in this matter, OPIC finds that each of the grounds, as explained by the Executive Director, is supported by petitioners' evidence. OPIC, therefore, recommends that the Commission grant this petition and appoint a review panel with the members recommended by the Executive Director to conduct further inquiry. I'm happy to answer any questions that you may have. Thank you.
Thank you. I have none. Colleagues?
Likewise. Thank you.
No questions, thanks.
Well, it seems like we're all pulling in the same direction on this one right now. There's ample cause to grant the petition, certainly, so I think we should go ahead and do just that. Appreciate the board again for being here today and look forward to your working with the panel. I want to thank those folks who have volunteered to serve on the panel. That's a real service to your community and to the state, and we very much appreciate it. I'm hoping that this won't be such a heavy lift since it sounds like we have a cooperative district to work with, but I appreciate your service. Other thoughts?
I echo that, and I appreciate the work that the ED's office did in order to come up with a panel to seek out those people for us today, and I appreciate the board members traveling in. It's a long trip, and appreciate the comment about forward thinking. So that's what I'd like to see happen.
Very much so. As reasonably as possible, as efficiency can ever be fully achieved in government work, I love to see it moving in that direction. So thank you.
I'll entertain a motion.
I would move that we grant the petition for inquiry against Starr County Groundwater Conservation District, appoint a review panel consisting of Dirk Aaron as the chairman, Lynn Smith, Zach Holland, Micah Vulgaris, and Joe Cooper as the 4 other members, and Peggy Hunka, PG, as the non-voting recording secretary for the review panel, and direct that the review panel's inquiry to consider and adopt a report be performed in accordance with Texas Water Code 36.3011 and 30 TAC 293.23.
Second?
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Thank you all.
That takes us to the enforcement docket, which is items 4 through 31. The executive director's staff is here to present these matters. On items 9, 11, 13, and 33, we also have several individuals who have signed in but indicated that they don't wish to speak. Their presence will be noted for the record.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Janice Hernandez, and I'm the Agenda Coordinator for the Litigation Division. With me today are Gitanjali Yadav, also of the Litigation Division, and Brian Sinclair and Melissa Cordell of the Enforcement Division, representing the Executive Director. Pending before you are items 4 through 31. The total assessed administrative penalties are $658,758, with $99,977 deferred, $145,916 applied towards supplemental environmental projects, and $412,865 to the general revenue. The Executive Director respectfully requests approval of these items, and we're available to answer any questions you may have.
Thank you. I have none. Colleagues?
No questions, thank you.
None at this time. Thanks.
OPIC.
My office reviewed these items, and we recommend approval of the proposed orders as presented by the Executive Director.
Thank you. I agree. I think it's appropriate to move forward with approval.
And I can make a motion. I move that we adopt items 4 through 31 as recommended by the Executive Director.
Do I hear a second?
I second that.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Thank you.
Item number 32 is consideration of the monthly enforcement report, and the Executive Director's staff is here for that item as well.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Melissa Cordell of the Enforcement Division, and with me is Brian Sinclair, also of the Enforcement Division, and Gitanjali Yadav and Janice Hernandez of the Litigation Division. We are here to present the monthly enforcement report for fiscal year 2019 through August. There are 1,307 effective administrative orders issued, and of those, 153 contain supplemental environmental projects. These orders assessed a total of $12,015,143 in penalties, with a payable amount of $7,480,977. $2,728,870 are to be paid towards supplemental environmental projects. 16,967 notices of violation have been issued through either our field offices or review of self-reported data in our central office, and 1,867 enforcement action referrals have been received. There are 1,688 pending administrative orders, with 118 cases that are on the backlog. 198 cases are pending at the Attorney General's office for representation in district court, and 30 judgments have been issued. 1,980 cases are being tracked for compliance. We've included for review a summary of OCE investigative activities for fiscal years 2017, 18, and 19. We are available to answer any questions you may have.
Thank you. I have none. Colleagues, any questions?
No questions for me. Thanks.
OPIC.
Thanks for the report. I have no questions.
Thank you very much.
Item number 33 is consideration for publication and hearing on proposed amendment to 30 Texas Administrative Code, Chapter 295, Water Rights Procedural Section 295.159. We have several people who have signed in on this matter, but it indicated that they don't wish to speak, so their presence will be noted for the record, and the Executive Director's staff is here to present this item.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I'm Dr. Kathy Alexander with the Water Availability Division, and with me today is Robin Smith of the Environmental Law Division. The proposed rulemaking would add Section 295.159C, which would provide an exception from the notice requirements in Sections 295.159A and B relating to an application for an extension of time to commence or complete construction of a reservoir designed for storage of more than 50,000 acre-feet of water. A public hearing will be offered on this proposal in Austin on December 3rd, 2019. Staff respectfully recommends approval to propose the publication of and hearing on Chapter 295, Water Rights Procedural. Staff also respectfully requests permission to make non-substantive revisions to comply with Texas Register requirements. Thank you, and we're available for any questions.
Thank you. I have none. Colleagues?
No questions. Thank you.
Yeah. OPIC.
OPIC recommends approval for publication of and hearing on the proposed amendment to 30 TAC Section 295.159 as presented by the Executive Director.
Thank you. I think what we have here is an unintended gap. It's a little bit out of step. Our regulations are a little out of step with the regulations or with the statute. So I think we should go ahead and propose this and receive comments.
I agree.
I will make the motion that we approve the publication of and hearing on proposed amendment to 30 Texas Administrative Code, Section 295.159, as recommended by the Executive Director.
Second.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Thank you.
Items 34 through 36 will be taken up together, and they involve the consideration of the publication and hearing on new, amended, and repealed sections of 30 Texas Administrative Code, Chapters 33, 35, 39, 50, 55, 60, 70, 80, 90, 101, 116, 205, 285, 294, 305, 321, 330, 331, 332, 334, 335, and 350, and the corresponding revisions to the state implementation plan.
That's a mouthful. Good morning.
Good morning. Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I'm Janice Hudson with the Environmental Law Division, here to present these three agenda items. The proposed rulemakings are in response to the quadrennial review of Chapters 39, 50, 55, and 80 conducted earlier this year. On June 12, 2019, the Commission determined that certain rules in each of those chapters were obsolete and no longer needed. The first of these rulemaking projects would repeal those rules. The remaining two rulemakings would make necessary amendments to rules and add new rules in response to the repeals. In addition, various stylistic, non-substantive changes are included in these proposed rules. The proposed amendments are organized as two rulemaking projects because 12 of the rules in 4 chapters require revision to the state implementation plan. If adopted, those amendments will be submitted to the EPA for review and approval to the Texas SIP. Public hearings will be offered on these proposals in Austin on December 10th, 2019. The Executive Director staff respectfully recommends approval to propose the publication of and hearing on the repealed rules in Chapters 39, 50, 55, and 80, the proposed amended rules and revisions to the SIP in Chapters 39, 55, 101, and 116, and the proposed new and amended rules in Chapters 33, 35, 39, 50, 55, 60, 70, 80, 90, 205, 285, 294. 305, 321, 330, 331, 332, 334, 335, and 350. The Executive Director's staff also respectfully requests permission to make non-substantive revisions to comply with Texas Register requirements. I'm available to answer any questions you have.
And I have none at this point. Commissioner Lindley?
One quick question. Just curious, who approved you being able to retire, Janice?
It was me.
Well, if I could make a motion to make you stay, and I would, but I won't. I'm in agreement that we should approve the publication, but appreciate all the work you've done on this and everything else for this agency.
Thank you very much.
Mm-hmm.
It's very nice.
Commissioner Janeka?
I have to second Commissioner Lindley's sentiment on that note. I do want to ask when might be appropriate to have a short discussion on an observation that maybe some informal direction to ED for development of the preamble on the adoption
let's do that
round
now.
of this rulemaking.
Yeah.
I noted some of our good folks in General Counsel's office observed that while the rulemaking is intended to really largely be non-substantive, repeal outdated rules and not make any policy changes, I think there is some potential for confusion. In particular, there were some elements for public notice for municipal solid waste modifications and minor amendments and Class 1 industrial hazardous waste modifications currently contained in Chapter 30, TAC 39.11, which are being proposed to be included in the new 39-1003B, 39-1005B, and 39-1011B. However, the elements in the list are being modified to only include those portions of the former rule that are applicable to each type of permitting action, while the older rule had a more general applicability. My concern is just that it seems like rules are falling off when, in fact, it's really only the relevant portions of the rule that still pertain to substantive rules that remain in the code. And my request would only be that if we might encourage the Executive Director staff to consider inserting into the preamble some additional couple of lines that would just provide a little more information to the public regarding the Commission's intention to only move over applicable requirements from the outdated rule. In my opinion, that helps improve public understanding of the rulemaking and may eliminate questions about the omitted portions of the outdated rule. I'm confident that many members of the public read the entire preamble start to finish, so I feel like that would be an improvement on our process to help allay a little potential for confusion.
Thank you for that. Commissioner Lindley, any thoughts?
Supportive of those comments. I mean, anything we can do to help the public explain what we're doing a little easier, a little more, have it written so it's a little more understandable is always a good thing. So
yeah, and I was aware of those concerns as well, and I think it's appropriate to handle those in preamble language. So
perfect.
We can wrap that into a motion when we get there. Mr. McWhorter.
OPIC recommends approval for publication of and hearing on these proposals as recommended by the Executive Director.
And I agree with that. Janice, did you have something to add?
We do have some language that I can briefly read, and we can provide the copies to you.
We'll take both. We'll take the reading and the copies.
Okay.
You can go ahead when you're ready.
This would be in the preamble on page 2 of Chapter 39, and it's item number 36 on the agenda, Rural Project 2009-121-033 LS. And the text would read as follows: the proposed rules in subchapter P carry forward only the portions of the rules that are currently applicable to the types of applications in new sections 39-1001, 39-1003, 39-1005, 39-1007, 39-1009, and 39-1011, and do not add or remove any current notice requirements for these applications. The addition of new subchapter P would increase the ease of understanding the applicable notice requirements for these applications.
Thank you. Colleagues, how does it look?
I think that directly addresses the potential area for confusion.
I think so too. Mr. McWhorter, what do you think?
I agree.
All right. Well, I'll entertain a motion in just a moment, but recognizing your retirement, Janice, I'm going to take my opportunity to lay it on a little bit. And first of all, I want to say that this agency is fortunate to have great talent and great people in every corner of every program. And Janice is, of course, both of those things, a great talent and a great person. I don't know if, Bobby, you in particular, I think Emily and I may have talked about our history together, but Janice and I have worked together for at least 8 or 10 years, and she was really my guide through the Clean Air Act and mentor on the authorities and the arguments to be made in some litigation that we were handling at my time at the AG's office. And I was purportedly the attorney and she my agency client, but in fact I was really more the scrivener, writing down her great arguments, and we ended up having a lot of success. And it was Janice and a host of other staff personnel and lawyers at the AG's office, et cetera. But that was one of the first glimpses into the quality of professionals that we have at this agency. And much to my delight, when I was appointed commissioner and got to come to this agency, I realized just that we have an embarrassment of riches here. But I've said this many times. I'll say it for the benefit of whoever may be tuned in and sitting out here today. Janice really made me look good. She was great for my career. She gave me arguments that were really largely successful. And so, Janice, I will always appreciate that. I cherish our friendship. I really appreciate for what you've done for me personally, what you've done for this agency, and what you've done for the state of Texas. And we'll miss you, but I'll look forward to seeing you at your retirement party.
Great.
Yeah.
Thank you so much. That's very, very kind.
Thank you. I guess we need a motion.
I would love to. Thank you. Mic is on. Thank you. I'd love to make the motion that I would move we approve the publication of and hearing on new amended and repealed sections of 30 Texas Administrative Code chapters 33, 35, 39, 50, 55, 60, 70, 80, 90, 101, 116, 205, 285, 294, 305, 321, 330, 331, 332, 334, 335, and 350, and corresponding revisions to the state implementation plan as recommended by the Executive Director, and including the modification of the preamble recommended by the Executive Director at agenda today.
Second.
The motion has been made and seconded, and it was impolite of me not to give you an opportunity to speak, Janice. So before I call the vote, the floor is yours if you have anything to say.
I have been here, at the end of this month, it'll be 27 years and 5 months. And that's a long time. It's time to retire, but I will miss so many people here. I really have enjoyed working here, and thank you for your kind words.
Thank you, Janice. The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Thank you.
That takes us to items 37 through 41, the quadrennial rule reviews for chapters 111, 220, 323, 333, and 344 of the Texas Administrative Code, Title 30. And the Executive Director's staff is here to present these matters.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Patricia Duran with the General Law Division, and with me today is John Mentor from the Environmental Law Division. Pending before you are items 37 through 41, the adopted rules reviews of 30 TAC Chapters 111, 220, 323, 333, and 344. As required by Texas Government Code Section 2001.039, Executive Director staff conducted rules reviews of these chapters to determine if the need for the rules within these chapters continue to exist. The proposed notices of the reviews published in the May 24, 2019 issue of the Texas Register with a 30-day comment period. No comments were received during the public comment period for these reviews. Based on the reviews of these chapters, the Executive Director has determined that the reasons for the rules continue to exist. In the course of these reviews, the Executive Director determined that the following are obsolete and will be addressed in a future rulemaking action. 30 tax sections 111.111, subsection A, paragraph 4, subsection A, and subsection A, clause 2, section 111.113, 111.175, 111.181, and 111.181 reference outdated sections of the Texas Administrative Code that have either been repealed or replaced, thus they are no longer needed. Additionally, we have some items for you. I'm going to be requesting to add language. Staff requests to add language to the Rules Reviews Notice for Chapter 323, indicating that the chapter implements Texas Water Code, Section 26.033, relating to rating of waste disposal systems. In conclusion, we respectfully recommend approval of the adoption of the Rules Reviews of 30 TAC Chapters 111, 220, 323, 333, and 344. Staff requests authorization to make non-substantive revisions necessary to comply with Texas Register requirements. Thank you. The project managers and attorneys assigned to each of these chapters are with us today to answer any questions you may have.
Thank you. I have none at this point. Commissioner Lindley?
No questions either. Thank you.
Likewise. Thanks.
Great. Mr. McWhorter?
OPIC recommends adoption of these quadrennial reviews and readoption of these chapters as presented by the Executive Director.
And I agree with that. My one question, and I had answered this in advance, is when will it stop? And I understand we're looking at February as the end of this round of quadrennial reviews.
Correct.
Anyway, yeah, appreciate that.
Is it because you don't want it to stop? You enjoying them so much?
I'm ready for it to stop.
It'll be good to have these
February
completed.
works.
Yes.
Yeah. Thank you.
I don't have any other questions, and I'm in agreement with it. We should adopt what's been proposed today, and I can attempt a motion unless you have comments or.
No comments from me.
Okay, I will try this. I move that we adopt the rule revisions and re-adopt the rules in 30 Texas Administrative Code, Chapters 111, 220, 323, 333, and 344 without amendment. Well, I guess I shouldn't say without amendment. We will have an amendment that was proposed today to agenda on Chapter 323. So is that right? Is that how I should include that? To the preamble. End of sentence. And then also that we direct the Executive Director to initiate a rulemaking to eliminate the obsolete sections identified by the Executive Director in 30 Texas Administrative Code, Chapter 111, before the next quadrennial rule reviews of that chapter. Yes, I do want to try it again. Anyway.
Make the new guy do it.
Oh, we already made him once. Actually, I wanted to call him out and have to try and make him review all the code chapters from the last item because there were so many.
Be an auctioneer if this doesn't work out.
I think we're past initiation, being able to do that to him. So I'm going to try again. Adopt the rule reviews and re-adopt the rules in 30 Texas Administrative Code, Chapters 111, 220, 323, 333, and 344, including the amendment proposed today as part of the preamble to Chapter 323. Does that cover that? I'm going to do that next. Yeah. And to direct the Executive Director to initiate rulemaking to eliminate the obsolete sections as identified by the Executive Director in in 30 Texas Administrative Code, Chapter 111, before the next quadrennial rule reviews of that chapter.
I second that motion.
I heard a motion and a second. All those in favor say aye.
Aye.
The motion carries. Thank you.
Thank you.
Items 42 through 45 are for closed session, and the Commission will meet in closed session in room 4222 in Building F at 10:40, as permitted by the Open Meetings Act, including Texas Government Code Sections 551.071 and 551.074, to take up and consider matters pursuant to items number 42 through 45 as posted and noticed.
The time is 10:20, and we are in recess.
The commission met in room 4222, Building F, for closed session from 10:30 a.m. until 10:55 a.m. on item numbers 43 through 45, as posted in notice pursuant to Texas Government Code Section 551.074. No action was taken. The time is 11:04. The agenda stands adjourned.